Welcome back. Our expert analysis today from Carl B. Grant, trial attorney, continuing on WIS at 5:30 in the double murder trial of Alex Murdaugh. And Cynthia, compelling testimony today about everything from guns found at the residence to the theory of the crime. But Carl, thank you once again for your expertise and your insight. I want to start with something that we heard played in the courtroom just a short time ago. Nick Neville and Greg Adeline are covering the courtroom in the trial proceedings. It was a compelling piece of audio where we hear from Alex Murdaugh himself talking about what he discovered upon the crime scene. I have a feeling the jury may want to listen to this more than a couple of times, but let's take a listen, then I want to get insight from you.
It was just so bad. They did it so bad.
You asked the defendant about the traumatic picture that he saw of Paul and Maggie. What did he say?
It's just so bad. I did him so bad.
I did him so bad.
Yes, sir.
Now, what do you make? I mean, we have to also emphasize the jury is actually seeing the video. We're hearing the audio. That video clip will be released once the judge gives the clearance to do so. What do you make of that moment in the courtroom and how compelling it may have been?
It could be a very compelling moment. The question becomes, what did he really say? Did he say, I did him so bad? Naturally, the jury is going to listen to that several times to determine exactly what the words were. Then they're going to have to put that in context. So what did he mean by that? Can we make a giant leap in argument that the comment, I did him so bad, truly amounts to a confession? So that's really, they got to put it in context of what he meant by that. And of course, the question becomes, is the defense going to be able to explain that?
And also, I mean, we saw reports from the courtroom that it looked as if Alex Murdaugh was shaking his head, potentially saying, that's not what I said. Maybe it was, they did him so bad. If he's saying that, why wouldn't the defense then object there? Is there a reason for that?
Well, the defense objects obviously to anything that they don't think want to come in. They don't want to come in because it's going to hurt their client. Why they did not object, that's for the trial lawyers to decide. We don't object to everything, but if something is going to be hurting us as far as it not representing what really occurred and it misrepresents the truth, then naturally, normally objection comes about.
And obviously the jury has got to be making comparisons to his demeanor, and people are thinking about how would I have felt in that moment. It's hard to really say in that circumstance, but you know, the demeanor that they see in the courtroom is very different from what they're watching and listening to in testimony.
Absolutely, and it's very important to understand that a witness's demeanor, even an implied witness who's being shown up on videotape, is actually evidence in the courtroom. So when a witness is on the witness stand, or being an imputed witness, if you will, their demeanor is evidence in the courtroom, and the judge will charge on the witness's demeanor to the jury.
Wow.
And, you know, also, so that statement where he testified, the law enforcement officer testified that he said, I did them so bad. That was the second interview that we've seen Alex Murdaugh do with law enforcement 3 days after the murder. He also said, they asked about the weapon, and he said, well, it's been missing. I thought maybe we just misplaced it. But he said he did not file a police report for that missing weapon. What do you make of that, and what do you think the defense could do going forward in this case?
Well, that could be problematic. We're talking about an AR-15 rifle, is my understanding, who loses an AR-15 and does not report it to the police. So that has to be explained, obviously. That could be problematic. The question about all of these guns, though, is this. You've admitted all of these guns, a rifle and I think maybe 3 shotguns. But have you admitted the actual gun that was found to have killed the victims? You have a lot of guns, no doubt about that, but the question is, have you proven to the jury beyond a reasonable doubt that any of these guns was used to kill the victims? And that's going to be an important question for the jury.
And you know what, Carl, that's a perfect segue, because the defense objected over and over and over again as each of these guns were entered into evidence. But ultimately, Judge Newman allowed it, saying that he found that evidence to be more probative than prejudicial. Explain that to us.
Sure. Under the rules of evidence, Rule 401 of the rules of evidence defines what relevant evidence is. If the judge finds evidence to be relevant, he or she must then do what we call the balancing test to determine whether or not its probative value is outweighed by substantial and unfair prejudice. So when the judge did the balancing test, he concluded that it did not. In other words, it might be prejudicial. All evidence is prejudicial to one side or the other, but it's not substantially and unfair prejudicial, therefore he let it in. Now that's the decision the court made. It could be an issue for appeal, but here's the thing about appeal. In order for a judge to be reversed on appeal for an issue of evidence, the appellate counsel must be able to prove that it was an abuse of discretion That's a very high
A
standard.
very high bar.
Yes.
Very high bar.
Okay, yeah, and I think we have some sound that we wanted to hear, correct? about
Well,
when they
yeah,
were
this is
entering
a
that?
moment in the courtroom. Let's start with, I think what we have first is the defense theory. There's so much that happened in court
Yes.
today. But the defense theory, because they've been trying to, as you talk about building those blocks, trying to get to the point where they are asserting the possibility that there were two shooters. So let's take a listen to that, and then I have a question for you about that theory, whether it really will help the defense. Let's listen to them.
Is it a possibility that there are two shooters, based on the data you collected?
It just indicated it was movement to me.
Movement from here all the way up to here?
I don't know that it went all the way up there.
But is it, I'm not telling you, I mean, one explanation would be movement, correct? One explanation would be two shooters. I'm sorry?
I
Yes?
wasn't there.
No. But one explanation of this data would be two shooters. One explanation, not the, but one.
Not the only one.
Yeah, not the only one, but it is a reasonable explanation, just like one shooter running up that way, correct?
Sure.
So one of the reasonable explanations is there are two people there, there are two guns there, one's a shotgun, one's an AR, and we now see that that AR is being shot from way up here, correct?
I can't see that, no. It's somewhere along that line.
And that line goes a dozen, 2 dozen, 3 dozen yards from the feed room, if you follow it straight up.
I don't know where they were within that line.
Could someone have been a lookout there? They went there to kill Paul, and that's the lookout. Maggie surprised them. They thought she was gone.
I have no idea.
Reasonable though, right? Right?
I have no idea. I wasn't there.
Listen, we wanted to share a longer exchange there with you because they had to drive all the way around the farm, so to speak, trying to get to this theory that there could have been two shooters. But is that really a convincing argument for the defense to make? Because you could still allege that your client was one of them.
The problem in using that theory is this. You may not be able to prove that there were two, but even if you do prove that there's two, if the prosecution can prove that your client was one of them,
Right.
under South Carolina law, the hand of one is the hand of all.
The hand of one is the hand of all.
But do you think this is, just the defense trying to put doubt in the mind of the jury at this point? We're seeing this a lot, where it's these theories that are kind of thrown out, these pieces of evidence that are thrown out, but it's not totally driven home yet. So what do you think the strategy is there?
The strategy is to do exactly what you said, create reasonable doubt. That's a very high standard. Not only does the prosecution have the burden of production to produce the evidence, they also have the burden of persuasion to persuade the jury that it is what they claim it to be beyond a reasonable doubt.
All right, we need to take a quick break. When we come back, we want to talk about some other evidence that was entered into testimony today, much more with our trial expert, attorney Carl B. Grant, right after this.